So you're working for an employer. You stop working, whether it be because you're fired, whatever the case may be. And now, a period of time later, you decide to file a lawsuit against your employer, whether it be for racial discrimination, whether it be for some type of retaliation against you, whether it be discrimination, retaliation, hostile work environment, whatever the case may be. Then a few months later, you eventually apply for Social Security disability benefits. And then you find yourself at this magical point wondering why your current employment attorney is so worried about what's going on with your Social Security case. Here's how that comes into play. First of all, please forgive me. I don't want to generalize and put all employment cases in the same context because there's different types of employment cases. Fair Labor Standards Act may come into play, FMLA, FMLA, Family Medical Leave Act. It really depends on the type of your case. But at the end of the day, let me tell you why your employment attorney is worried. Your damages. And you would say, I don't understand. Let's take a normal discrimination case. Not saying that any discrimination case is normal, but just a normal for purposes of how it litigates out. One of the things that you're doing whenever you sue someone is not only are you telling someone that somebody had a duty to do something, there's a breach of that duty, there's a causation between the duty and that breach that you can, of course, tie to the employer, and more importantly, you were damaged. Now, the idea of damage in an employment setting is a lot different from a personal injury standpoint, products liability, or something so forth like that. When you're talking about your damages, it typically falls into two categories: compensatory damages and impunitives. Compensatory damages is really what we're talking about. Punitives is going to be different. It's going to vary from state to state. But really what punitive damages is where you're trying to punish somebody for their wrongdoing, meaning they just did something that was so, the word they use is egregious, but it's a nice way of saying it was so bad that we got to send a message to you and other employers that this type of conduct is not permitted. Now, everybody swears that anything that happens to them, they should be punished for, and punitive damages should come. But the idea is that you're going to want to, or your attorney is going to want to demonstrate to a jury, because usually punitives are only awarded at the jury level. Typically, you very rarely find a judge that issues punitive damages. The punitive damage portion is really what you're trying to do is sell a jury that the conduct of your employer was so bad that you want to send a message to that employer, as well as subsequent employers, that that type of behavior is unacceptable. Now, that is different from the context of compensatory damages, which is why your employment attorney may be concerned. In a concept of compensatory, we're talking about those things you physically lost, which is usually benefits, past wages, things that you have actually lost. So probably the more common things we call back pay. And in some instances, there's called front pay. Well, let's kind of talk about the two. Back pay is basically any money that you lost from the period of time that relates to from the time basically usually up to the date of when they make that final determination to the point of when you actually lost work. So let's say you got fired in January of 2013, you filed your lawsuit, we're now in January of 2014, you've got at least a year worth of lost wages during that time period. You know that right out the gate. Okay? Now, one of the things that you want to look at is when the defense attorney is going to look at it, they're going to look at is, have you mitigated those circumstances? Meaning, first of all, have you tried to go to work? Because they're going to argue that any benefits that you receive and any lost wages should be adjusted by any wages you receive from working someplace else. And more importantly, were you actively looking? So let's say you were actively looking, no big deal, and so forth. Now you're also trying to go for front pay. Front pay is, had you still been working there, this is how much work you should be getting going forward. So let's say it was a job you had been at for 10 years or 15 years and there was no reason to believe you weren't going to leave anytime soon. Then you make the argument to a jury or to the court, to the judge, that you should also be entitled for monies going forward as well. Social Security can be a little tricky. And this is where you need to get a good employment attorney, if you don't have one, to help you make sure you address this accordingly. Because a defense attorney is going to basically say that if you're getting disability benefits, in theory, you wouldn't be working anyway. Think about how the logic of that plays out. Like I said, this is why I say it's important to get an employment attorney who does this on a regular basis, because they can help you maneuver those nuances. But just kind of think about this for a hot second. You're asking a jury to not only award you back pay from the period when you haven't worked, but front pay going forward. But let's say that on the day of your jury hearing, you also just got approved for disability benefits. Then the question then becomes is, well, how are you able to work? If they're saying that you can't do any work, then in theory, you would not have been able to work here going forward. See how that plays out? So it becomes a little weird. Now, it's not saying that you can't file a lawsuit, because there's law, like in the American with Disabilities Act, there is language that talks about, not in the specific act itself, but there is language in various laws out there that says, you know what, you can apply for both. You can apply for Social Security and sue under the ADA. I just tell people that if you've got an employment case, or if you're thinking about suing for discrimination, or even under the ADA or anything like that, you need to make sure that you have an employment attorney who can explain to you what the ramifications and the impact of you applying for Social Security. Now, let me throw this out here, food for thought. Please don't think that I'm telling you to not apply for Social Security while you have a pending case in court for discrimination, for fear that it's going to impact your case. That's not what I'm telling you to do. I'm not telling you that you need to either sue or apply for disability benefits and not do both. I don't want you to think like that. What I'm telling you is this. If you believe that in the course of a discrimination or employment case that you're thinking about applying for disability benefits, find out from your employment attorney. Find out from your employment attorney what impact a determination of disability by Social Security is going to have on your case. It's better that you know in this way and let your attorneys work it out. And I say this because I've worked with a couple of plaintiffs' attorneys in the past with regards to, I was working on a Social Security case for their client, and on the flip side, they were doing the employment case, and we were just kind of working back and forth so they could get understanding. But I stress this wholeheartedly. I don't want you to go in here freaking out, because I know somebody's going to watch this video and go, oh my God, I need to drop my Social Security case because of my employment case, or vice versa. Oh my God, I got to drop my employment case so that it won't hurt my Social Security case. That's not what I'm saying. That's one of the reasons why you hired attorneys. Make sure you let both attorneys know. If you've got an attorney for Social Security and one for your employment lawyer, let them know, hey, I'm suing for this. Is it going to impact this? I'm applying for this. Is it going to impact this? So this way, they can inform you about the impact of all the programs relating to each other. So that this way you will know what to expect in the worst case scenario as it relates to your case in the employment setting, in your case for Social Security.